Joining us now via the phone is the senior judicial analyst for Fox News Channel, Judge Andrew Napolitano. He provides legal analysis on both Fox and the Fox Business Network. His newest book is "It is Dangerous to Be Right When the Government is Wrong." And Judge Napolitano, thanks so much for being with us today.
No, it's a pleasure to be with you, Kathleen. Thank you for having me.
Well, the Supreme Court begins hearing 3 days of oral arguments in the 26-state challenge to President Obama's sweeping health care law. Take us inside the courtroom. Exactly what happened today?
The challenge today had to do with whether or not the challenge itself is timely. The Constitution requires that the Supreme Court cannot give advisory opinions, but it can only be asked to undo harm that has already been caused or to prevent harm that is certainly on its way. And now normally the Supreme Court itself decides when a case is ripe, that is, whether or not it's timely. But in the case of paying taxes, the Congress has established a law telling the court when it is ripe, that is, timely, for the court to hear challenges to taxes. And Congress, in a law written shortly after the Civil War, decided that before a taxpayer can challenge a tax, the taxpayer must first have paid the tax. So the issue that was debated in oral argument today was, since no one has yet paid any tax or penalty, whatever you choose to call it, for not obtaining health care, because the obligation to obtain health care doesn't kick in until 2014, and the IRS is not going to assess taxes or penalties, whatever they are, until 2015, is this case ripe? That is, can the Supreme Court hear it? Now, I was not in the courtroom today, but from my colleagues who were, it is clear to me that the court believes the case is ripe because this issue of paying taxes is not the main challenge to the statute. It is a subsidiary challenge, but it is not the main challenge. And so the fact that no one has yet paid this tax or penalty should not be an impediment to the court hearing the case.
Okay, the challenge centers around two bigger issues. One, the individual mandate and whether it's unconstitutional for the federal government to force citizens to buy anything, including health insurance. And two, severability and whether any part of the act can remain if the individual mandate is struck down. You have said the justices will nix key parts of the law. Can you explain to us exactly which parts and why?
I think that the court will find the individual mandate unconstitutional because I think it will find from the plain meaning of the Constitution, we're talking about what's known as the Commerce Clause, which authorizes the Congress to regulate interstate commerce. From the plain meaning and the historical context of that clause, the court will rule that while the Congress can regulate interstate commerce voluntarily entered into, it cannot compel the involuntary participation in interstate commerce. Now, this distinction between regulating what people voluntarily put into interstate commerce versus compelling people to engage in interstate commerce has never been put before the court and thus has never been answered by the court. If I am right and the Congress does invalidate the individual mandate, then the second issue that you raised, Kathleen, comes into play, which is severability, which is a fancy legal phrase meaning can the court just sort of carve out the unconstitutional portion of the statute and let the remainder of it stay standing? Remember, this law is 2,600 pages long. Or does the invalidation of one part, even the most important part, invalidate the rest of the statute? So that's the second issue that the court will have to address if it does invalidate the individual mandate.
Is this case a slam dunk for the states, or are you concerned that liberal justices will attempt to legislate from the bench?
I'm always concerned when any justices want to substitute their judgment for that of the Congress. And conversely, I'm concerned when any justices refuse to enforce the plain meaning and historical context of the Constitution. And regrettably, this is not just a liberal versus conservative argument. The last time the Supreme Court looked at the Commerce Clause, which again is the section of the Constitution, the hook on which Congress hangs its hat to justify the enactment of this statute, it involved medical marijuana in the backyard. A person was growing medical marijuana in his backyard pursuant to a prescription given by a physician for some ailment from which the person was suffering, and the person was prosecuted by the federal government. The person's argument was, this is not commerce because I'm not selling it, and it's not interstate because it never leaves my backyard. The government argued, well, if we let everybody make this argument, then we'd have millions and millions of people growing marijuana in their backyard, and the cumulative effect of that would have an effect in interstate commerce. Some conservative justices accepted that latter argument. So you don't be surprised if some conservative justices say Congress can regulate anything that moves, and health care is 1/6 of the national economy. On the other hand, this is an area of human behavior, health care, that is not given to the Congress under the Constitution, and which has been regulated by the states and almost exclusively by the states for over 200 years.
Now, Americans overwhelmingly oppose the health care law. A recent Rasmussen Reports poll found that 56% of likely voters would somewhat or strongly favor repealing the law. Should the justices listen to the polls?
Well, I hope not, even though, and I make no bones about it, I am a fierce opponent of this statute. We really want the justices to interpret the Constitution on the basis of its plain meaning and its historical context, not on the basis of what the polls tell the justices the public wants. The Congress can listen to the polls, and the Congress is a political branch. It was elected by people, theoretically, to do their will. The whole purpose of the having an independent judiciary is not to be political. It's to be anti-democratic. It's to enforce the Constitution, whether it's popular to do so or not.
Okay, a ruling is expected this summer. Some expect the justices will rule 4-4, with Justice Kennedy being the swing vote. How do you think the justices will rule?
In preparation for a lot of my work here at Fox, I have devoured, I guess that's the best way to describe it, almost everything Justice Kennedy has written on the Commerce Clause. And though it's risky to predict these things, because you really can never know what's going on in another person's mind, I think I can say with some confidence, if Justice Kennedy is consistent with other things he has said about the Commerce Clause, he will vote with the 4 conservatives to invalidate the individual mandate, because I think he recognizes the big picture here is far beyond health care. The big picture in this entire case is whether the Constitution limits the behavior of the federal government to the plain meaning and historical context of the Constitution, or whether clever lawyers and politicians can interpret language in the Constitution so as to justify whatever Congress wants to do. And I think Justice Kennedy, along with the 4 conservatives on the court, will recognize that enough is enough. Now is the time to say the Constitution means what it says. It is not a blank check for the Congress to do whatever it wants.
Judge Napolitano, just how nervous is the Obama administration right now? And if the justices overturn Obamacare, does it make his reelection defeat all but certain?
If I were a lawyer in the Justice Department working on this case, I would be nervous that it will be overturned. However, I'm not so sure that overturning this in June will have an adverse effect on the president's election in November. I mean, the president may very well be able to say to the public, look, I tried. Every Democrat in the Congress, or nearly every Democrat, did the right thing. I'm making his argument. This is not an argument that I would make, you understand, and tried to get you health care and tried to keep you healthy. It was those black-robed judges and mainly the ones appointed by Republican presidents that prevented it from happening. So I could see, or I should say, I can hear the president making that argument to try and spin the invalidation of this, if it is invalidated, towards his side. On the other hand, if this is invalidated by this court, I think it will unite voters in opposition to the president's march towards socialism like they have never been united and will make his reelection very difficult.
How about the Republicans? If the ruling goes in favor of Obamacare, are you confident they can repeal, or is there a way for states to legislate around Obamacare?
It is very difficult for the states to legislate around it, and the only way the Congress could repeal this would be with either two-thirds voting to repeal it, to override a presidential veto, or a Republican in the White House who favors repeal. And they would need to do it very, very quickly, because there are many, many constitutional principles at stake here, one of which is once a benefit begins to flow, it is very difficult to stop the benefit. Democrats were aware of this in the manner in which they structured the statute. I mean, stated differently, if people start to receive benefits under this, because Medicare is now going to cover their health care, it would be very, very difficult for the Congress to take those benefits away.
Okay, is the repeal scenario you just described a possibility in early 2013?
Sure. If the president is somebody who is willing to repeal, and the Republicans have a majority in the Congress, a simple 5-line piece of legislation could repeal this if it got a majority of both houses and if the president signed it. But if they wait too long and benefits begin to flow, they're going to have a very, very difficult time taking benefits away from people who've planned their lives in anticipation of receiving them.
Judge, while we have you here, I'd like to get your thoughts on the Trayvon Martin case, which has also captured the nation's attention. President Obama last week said that if he had a son, he'd look like Trayvon. Why do you think the president chose to get involved in this, and what do you make of his statement?
I thought the statement was highly inappropriate and decidedly political. I say that as someone who defends the right to keep and bear arms, but who believes that this was a murder, and that Mr. Zimmerman should be prosecuted for murder. And in my view, on the basis of my limited understanding of the facts, Mr. Zimmerman will have great difficulty invoking the stand your ground defense in Florida, because that defense requires that you actually be the victim of an attack. And there is zero evidence here, I think, from which he could argue that Trayvon was attacking him. But for the president to say, if I had a son, this is what he would look like, is reprehensible. The president's job is to protect the liberties of everyone, whether they look like him or not.
Should Florida throw out its stand your ground law or keep it?
Well, I'm in favor of the stand your ground law, but I would be in favor of clarifying it, either via a judicial opinion or through the legislature. You must really be the victim of an attack before you can use deadly force on someone else. Otherwise, we have tragedies like this one.
All right, Judge Andrew Napolitano, thanks so much for joining us, and we appreciate you sharing your insight with us here on Newsmax TV.
No, it's a pleasure to be with you, Kathleen.